Thank you so much for your hospitality. It has been such an honor and a pleasure to be here and to get to know some really wonderful prosecutors here in Brazil. I really appreciate being able to share some information about how the United States handles plea agreements and cooperation agreements and other ways of ending criminal cases. Would it be possible to load my PowerPoint slides? So first, I'll set some expectations. So before I joined the National Association of Attorneys General, where I work with state prosecutors, I was a federal prosecutor in the Southern District of New York. So quite a bit of the information that I'll talk about today comes really from the federal system, where there are fairly clear requirements, where there's fairly clear standards, where it's sort of an area that I know quite well, but there are some differences in how the states handle things like cooperation. So know that there is some variety in the United States in how these different mechanisms are used to end cases. And now you're learning that I'm completely dependent on my PowerPoint slides. So I'll talk a little bit about the different areas that I'll be discussing. I will be talking about plea agreements, which in the federal system do not require a defendant to cooperate with the government. I will be talking about cooperation agreements, which do require the defendant to cooperate with the government, and then a couple of other ways that cases are ended, namely through something called an immunity order and through something called a non-prosecution agreement. Each of those ways of ending a case or requiring somebody to testify or provide information have different requirements, have different benefits, have different occasional problems, and are useful in different circumstances. Perfect. But before I go into those specific agreement or those specific types of agreements, I'll talk a little bit about how it is that prosecutors in the US have power to enter into plea agreements. I'll talk about how common they are, and I've heard some of that from some of the speakers already here today. And then I'll get into those 4 different types of plea agreements that I outlined at the beginning. So the power of federal prosecutors in the United States to enter into these different types of agreements is from our Constitution. It comes from our ability generally to execute the laws as members of the executive branch. That means that we have broad discretion to initiate, to start, or to stop prosecutions, to select specific charges, to agree to a guilty plea, and many of these powers are fairly unlimited. Our discretion is guided by the purposes of the criminal law, the assurance of warranted punishment, deterrence of future criminal conduct, both future crimes committed by the defendant and future crimes committed by other people who may be paying attention to what's happening to this case, the protection of the public from offenders, and a rehabilitation of offenders. That is, helping the defendants move past a life of crime. And I'll note on my slides, you'll see some small text on the bottom. Those are the citations to the sources that the information is pulled from. I'm kind of a nerd, so if anybody ever wants to talk about any of this at greater length, I'd welcome the opportunity to do so. So as you heard, plea agreements are quite common in the United States. This is a pie chart from 2018 that reflects in the federal system 90% of all defendants pled guilty. Another 8% or so had their cases dismissed, and only 2% chose to go to trial. Of that 2% that went to trial, 83% of them were convicted. So plea agreements are very common in the United States. This encompasses all kinds of plea agreements, both plea agreements where a defendant does not cooperate and plea agreements where a defendant does cooperate. Cooperation agreements, as I'll call that second category, happen about 10 to 20% of federal cases. You can also see that the number of trials in the United States in the federal system has gone down quite a bit since 1998. Plea agreements are also very common in the state court system. I have 4 different states here: California, Florida, Texas, Pennsylvania. The average number or percent of jury trials from 2012 to 2015 for those states is in some cases less than 1%, in some cases around 2%. For another state, New York, they're a little higher, but it's still only 2 or 3% of cases in the state systems in New York State that actually would go to trial. The rest of those would typically be resolved by a plea. As I said, I'll be talking about different types of plea agreements, what I'll call a regular or a straight plea agreement, where a defendant simply wishes to avoid trial, usually talks through his attorney to the prosecutor about what kind of resolution short of trial might be available. There is no expectation with these kinds of plea agreements in the federal system that a defendant will cooperate or collaborate or provide any information to the government. The second category are cooperation agreements. Those are agreements where a defendant and the prosecutor agree that he will cooperate with the investigation or with the prosecution. That can include assisting an investigation as it is ongoing, things like potentially wearing a wire, things like having telephone calls that are recorded by law enforcement officers. It also often includes being willing and able to testify if another defendant chooses to go to trial, or in other proceedings like grand juries or like hearings that don't involve the use of a jury. And then I mentioned 2 other categories, which are non-prosecution agreements and immunity orders. I don't know that I would call these plea agreements exactly, because a defendant does not admit guilt as part of them, but there are ways to resolve a case to ensure typically that a defendant is available to, or that a witness is available to provide some sort of an assistance or to be required to testify. And I'll talk a little bit about the differences between those as we go on. So talking now a little bit in more detail about the regular plea agreements. I'll talk about the effect of them, what it is that they mean. I'll talk about a few rules that govern what prosecutors do to get the plea agreements. I'll talk about a few statutory requirements for pleas. I'll talk about some example plea agreement conditions in the federal system, that is, the kinds of specific requirements in a plea agreement that the defendant is required to agree to, or that the prosecution agrees to let the defendant pursue even if he enters at a guilty plea. And then I'll talk a little bit about sentencing and other considerations. The effect of a plea agreement is that there will be no trial. You can sometimes still have hearings about what the defendant's sentence should be, but the question at that point is not whether the defendant is guilty, but it is whether the defendant should get a certain amount of punishment. So the person has already admitted guilt, but occasionally there are hearings about what the sentence should be. Plea agreements typically result in a shorter sentence than if a defendant lost a trial. That can include in cases that involve mandatory minimum sentences, that is, sentences that a judge is required by law to impose. Sometimes with a plea agreement, a prosecutor can agree to let a defendant plead to a charge that does not have a mandatory minimum sentence, or plead to a charge that has a lower mandatory minimum sentence as one of the sort of concessions for that plea agreement. A court will still consider, at the time a defendant who enters a guilty plea is sentenced, statutory and sentencing guidelines requirements. I'm going to take just a moment to talk a little bit about the U.S. sentencing guidelines, just so that people have a general understanding of how they work. So I mentioned that there can be mandatory minimum sentences in the United States. You can also often have a statutory maximum sentence, that is, the highest sentence that a judge could impose. To help the judge decide where in that range to sentence a defendant, there are things called the United States Sentencing Guidelines. Those guidelines contain information that the judge should consider when deciding what sentence to impose. As one example, the guidelines tell the judge to look at the defendant's position in an organization. If a defendant is a leader in the organization, then typically the guideline sentence, the recommended guideline sentence, it's not required, will be higher than if a defendant is just a low-level person in the organization. For fraud cases, the sentencing guidelines say that if you have stolen more money, the sentencing guideline recommendation will be higher than if you're somebody who has stolen less. So you have this sort of complicated system of guidelines that help the judges determine how to exercise their discretion when it's time to sentence someone. Now, moving back to the plea agreements, they can include agreements between the government and the defendant about the facts of the case, the sentence or the sentence range, including sometimes guideline stipulations, like whether somebody is a leader or whether somebody is actually more of a small person in the organization. And the plea agreements will often include information about charges or conduct that the prosecutor will not continue to pursue as a result of the plea agreement that the defendant has entered into. Plea agreements are generally unreviewable by a court. I have an asterisk there because there are some exceptions to that, which again, if anybody would like to talk with me after, I'd be happy to get into. But generally, prosecutors have a great deal of discretion. In the federal system, which sounds fairly similar to Italy in this way, the judge is not part of the plea agreements. The judge's only role can be to refuse to accept a plea, and that usually is if the plea doesn't comport with some requirements that I'll talk about in a few moments to sort of ensure that the plea is voluntary and knowing. There is one circumstance where a judge kind of can get into the can reject a plea for more substantive reasons, and that is in a particular kind of plea agreement under Federal Rule of Criminal Procedure 11C3, where the government and the defendant agree to a certain sentence. If there's a plea agreement that contains a specific sentence and the judge doesn't think that that's the sentence that the judge will want to impose, the judge can warn the defendant that he doesn't plan to do that, and the defendant can choose not to plead. But that's sort of the only time that the judge is really involved in the federal system in the details of a plea agreement. Now I'll talk a little bit about the constitutional requirements. I mentioned this before, that guilty pleas must be knowing and voluntary. That includes that a judge is required to tell a defendant during a plea hearing where the defendant is placed under oath and tells the judge that he wishes to plead guilty, that he is giving up certain constitutional rights, which include the right to remain silent, the right to trial, the right to confront accusers, and also about certain collateral, that is sort of secondary conditions to consequences to a conviction, including, as one example, potential immigration consequences. Oftentimes, if somebody pleads guilty to a serious case in the United States, if they are not a United States citizen, they can be subject to deportation. The Supreme Court has made it clear that that's something that judges need to warn defendants about if defendants choose to enter a guilty plea. Now, I said that the plea must be knowing and voluntary. To determine if a plea is voluntary, the judge will make sure that all of the promises are in the plea agreement, the written document, or on the record. The judge will ask the defendant if any threats have been made to induce the defendant to enter into the plea. If the defendant says yes, then the plea will not go forward. And the court is also required to address the defendant directly. It can't just be the defense attorney who says all of these things. It's got to be the defendant himself or herself. Now, some of these constitutional requirements have been further refined in a statute that sets forth what it is that the judge has to ask the defendant about to make sure that the plea is knowing and voluntary. Some of these overlap with what I've already talked about. You'll see a few others. They include that the defendant has to be under oath. The court has to inform the defendant of the right to use his statements in a subsequent prosecution for perjury or for making a false statement. that the defendant has the right to plead not guilty or to request a jury trial, and that the defendant has the right to counsel, as well as the right to confront and cross-examine witnesses, to testify himself if he wishes, to call his own witnesses, and to present evidence. There are some others, but you get the idea. This is something that, again, in the federal system, the judges go through each of these rights and ask the defendant to ensure that he understands what all it is that he's waiving. Now, I'm going to talk about just one example plea agreement in a case that ended up before the US Supreme Court, because it'll give you an idea of some of the other things that a defendant often waives, that is, gives up as a result of a plea. In this case, the defendant waived all defenses based upon the statute of limitations, which basically requires prosecutors to bring charges within a certain amount of time after a crime has ended. He agreed to waive all of his defenses. Several specified trial rights, including the ones that I just listed. The right to appeal a sentence at or below a particular guidelines range. And most collateral, that is after the end of the case in chief, attacks on the conviction and the sentence. And various rights to receive or request information from the government. So as a condition of the defendant pleading guilty, he agreed to waive, to give up all of these things. The plea agreement also made it clear the defendant still had some rights to appeal, including any claims of newly discovered evidence. If, for example, evidence surfaced that the defendant was in fact not guilty of the crime, the defendant would still have the right to appeal even though he had this plea agreement. Rights to make claims about ineffective assistance of counsel. That is, the defendant still had the right to say, my lawyer did a bad job, perhaps of inducing me to enter into this plea agreement. He still, even with the plea agreement, has the right to make those claims on appeal. And then he also had the right to access certain statutes that provide for sentencing reduction. So this gives you an idea of just one example of the types of things in a plea agreement a defendant in the US, in the federal system, would typically waive, and types of things that he's allowed to preserve, that is, to keep, even if he chooses to plead guilty. And for sentencing in the plea agreement, there are a number of different positions that the government could typically take. That could include agreeing in the plea agreement that the government would not take, and by the government I mean the prosecutor, would not take a position about the sentence, could agree not to oppose the defendant's request for a particular sentence, could agree to request a specific type of sentence, perhaps even a fine or probation rather than incarceration, could agree to request a specific fine or a term of imprisonment, or to not request over a certain amount of imprisonment time or an amount of a fine, or to request, in cases involving pleas to multiple crimes, concurrent, that is, sentences that are served at the same time instead of consecutive, that is, sentences that are served one after another sentence. And I have some cites here to the Justice Manual. It is a useful guide for federal prosecutors that contains a lot of the information that I'm providing to you here today. That Justice Manual includes some other considerations, some other things that federal prosecutors should be thinking about when entering into guilty pleas with the defendant. That includes that the plea agreement should honestly reflect the totality and seriousness of the defendant's conduct. What's that mean? That means even if a defendant chooses to plead guilty, you should make sure that the plea reflects the seriousness of his conduct. If a defendant who was charged with committing a murder says, I'd like to plead guilty to bankruptcy fraud, you should not enter into that plea. That is not an appropriate way to resolve a case that is that serious. So this reminds prosecutors that their job is not just to reach a conclusion in a case, but to make sure that a plea agreement accurately reflects what really happened in the case. The Justice Manual also makes it clear that you should make reasonable efforts to notify victims and to consider the views of victims regarding a proposed or a contemplated plea negotiations. So you do have an obligation to weigh into your consideration what it is that the victims request. That doesn't mean that a victim has a right to overrule a prosecutor, but it means that that's something that the prosecutor should be taking into account. The Justice Manual makes it clear that restitution, that is money back to the victims, may be mandatory. And the Justice Manual also talks about some separations of powers issues, potentially in corruption cases involving members of other branches of the US government. Now I'm going to leave plea agreements and talk about cooperation agreements. Almost all of the same things still apply. That is, those same requirements to make sure that a plea is knowing and voluntary apply in cooperation agreements. But cooperation agreements require you to think about more things because you are entering into an agreement with somebody who is often a defendant in a case already for that person to cooperate with you in an investigation and or to provide testimony as a witness who you will be calling in your case and who you will be asking a jury in one way or another to believe. So it's a pretty serious sort of arrangement. So again, I'll talk about some of the rules that apply to cooperation agreements. I'll talk about the Justice Manual's requirements a little bit more. And I'll talk about the approach that my former office, the Southern District of New York, used in determining whether somebody should be permitted to become a cooperating witness. So I'm going to read this quote, and I'll try to be slow because I think it's actually sort of important. And it's important to see what date this court decision was issued. It was in 1987, so 30 years ago, a little bit more than that. And it says, "No practice is more ingrained in our criminal justice system than the practice of the government calling a witness who is an accessory to the crime for which the defendant is charged and having that witness testify under a plea bargain that promises him a reduced sentence." So in the US, the use of cooperators is something that's been happening for many, many, many years. I know that it's something that's relatively new in the system here. It sounds like it's been happening for even longer in Italy, but it is something that I think the system has grown to still scrutinize, still look at carefully, but understand can be a really important opportunity to hold sometimes incredibly dangerous or incredibly powerful people accountable. So I'll talk a little bit about just some constitutional principles. If you sign up a cooperating witness, if you enter into a plea agreement, a cooperation agreement with a witness who's going to work for you proactively, there are some constitutional requirements that you have to be careful about. You need to not do things like ask that witness to talk to a defendant who's represented by a lawyer. In the US system, that can be a problem. You need to be aware of your discovery obligations, that is, your obligations to provide to a defendant against whom this witness might testify certain information. That includes that if you have a witness who says things that are exculpatory, that make it less likely that your defendant is guilty, you have to provide that information to the defendant. You may be able to provide that in a way that protects the identity of that witness, but you still have to provide it to the defendant. If you have a witness who you choose to call to testify, and there's impeachment information about that witness, that is information that might make it seem like that witness is less credible, you have to turn that information over to the defendant's attorney in any trial where that witness might be called to testify. So I'm going to talk now a little bit about some of the ethical standards that the American Bar Association has set forth about using cooperating witnesses. Have most people heard of the American Bar Association? Can I get a quick show of hands? Because I don't want to assume, okay. There's, the ABA isn't, well, if I wasn't being recorded, I could say that they weren't that important, but I think that I am, so I have to say they are very important. But the American Bar Association is an entity that sets forth some ethical regulations for lawyers. Those regulations then are oftentimes adopted by individual state bars. Every attorney who practices in the United States has to be a member of at least one state bar. So when the ABA sends out information, then that information often goes to state bars. Those state bars then have power over whether lawyers can continue to practice. So that's sort of what the ABA is and why some of the ethical things that they have to say are really quite important. So they have some standards about cooperating witnesses, which I'll start calling, you'll see on the slides, just CW, which is short for cooperating witness. The ABA suggests, much like the Justice Manual, that you should ordinarily seek to have a cooperating witness plead guilty to an appropriate criminal charge rather than just to immunize that person. It also sets forth some factors to consider for leniency. It also says that a cooperation agreement shouldn't promise non-prosecution for any sort of future crimes. That is, you shouldn't give somebody an agreement that if they do something bad in the future, you're not going to prosecute them. It really should be just looking back at the crimes that have already been committed. They also make it clear that you shouldn't adversely affect third parties' legal rights. You shouldn't weigh into a civil dispute, basically, if there's a civil dispute associated with the crime that the cooperating witness is pleading guilty to. It also talks about needing to disclose those cooperation agreements, any promises, any information relevant for a cooperating witness's credibility to a defendant. It also says not to be alone with a cooperating witness if you're the prosecutor. And that is something that I and my office always followed. You never met by yourself with a cooperating witness. You always had an agent there. It's just not a good idea. Also, the ABA said that you shouldn't tell a cooperating witness to invade privileges by, for example, trying to talk with somebody who's represented by an attorney. The ABA sets forth some suggestions about the cooperation agreement itself, that is the contract between the prosecutor and the cooperator, which include that that contract should be in writing. It should cover only crimes that the government knows about. It should include the specific benefits and obligations. It should include any specific activities to be performed by the cooperating witness. It should require that cooperating witness to be truthful. Forbid criminal conduct by the cooperating witness, dispose of criminal and civil claims that the government has against the cooperating witness, contain all the promises, and explain any limitations that that agreement has, and include a remedy if there's a breach by the cooperating witness. And I'll talk about this remedy in event of a breach in a little bit, but that is something that my former office dealt with in a pretty specific way that I'll talk about. And I'll talk very briefly about just some of the model rules of professional conduct. These are the rules that the ABA puts out that the states often adopt that govern what every lawyer does in those states. That include that a lawyer cannot knowingly offer evidence that the lawyer knows is false. If a lawyer's witness testifies falsely, if you, for example, called a cooperating witness and that cooperating witness said something on the stand that you didn't believe was true, your obligations can include having to disclose to the court that you believe that your cooperating witness lied. They also have other requirements that a lawyer cannot falsify evidence, counsel or assist a witness to testify falsely, or offer any inducement to a witness that's prohibited by law. And require that prosecutors make timely disclosure to the defense of all the evidence of or information known to the prosecutor that tends to negate the guilt of the accused or mitigates the offense. This gets back to some of those disclosure requirements that I talked about earlier. It also talks about represented parties, again, that you can't seek to talk with someone who's represented by counsel unless that person's lawyer consents to you talking to them or you're authorized to do so under a law or a court order. What this would sometimes mean when we had multiple debriefing sessions with cooperating witnesses was that once they entered into a cooperation agreement, sometimes their lawyers would say, you're welcome to meet with my client without me. You're preparing for a trial, you need to have more time, but you would always make sure that you got that in writing to make sure that you wouldn't have any issues with this rule. I'll talk a little bit about what the Justice Manual says about cooperating witnesses. It does say that relevant considerations about potentially declining to charge someone can include whether that person's willing to cooperate in the investigation or prosecution of others, but it notes that generally speaking, just that somebody is willing to cooperate isn't a good enough reason to relieve that person of criminal liability. So it's a factor that you can consider, but it's typically not something that suggests that you shouldn't move forward with a case that you can make against somebody, even if that person wants to cooperate. It also talks about the Justice Manual, which again governs what federal prosecutors do. Talks about who can authorize a cooperation agreement. Talks about having to maintain certain records. It gets into a lot of the details that help offices determine how to move forward in the details of these sorts of systems. It also notes that if a cooperating witness is permitted to plead to an offense that appears unrelated in seriousness or scope to the charges of defendants that are on trial, that person's credibility is going to be attacked. Any good defense attorney will suggest that a cooperator has been given a really sweet deal, a really favorable deal, and that deal is what is motivating the cooperator to talk about his client, not that the cooperator is actually telling the truth. So this is a good reminder, and again, I'll talk about what my old office did in determining pleas for cooperating witnesses to plead guilty to, but the Justice Manual sort of more broadly makes it clear that you should be thinking about those issues. Now, one of the important components of the cooperation process on the federal side in the United States is a section of the sentencing guidelines called 5K 1.1. It basically governs cooperation. If a prosecutor writes a letter under this sentence and under a particular statute, it allows the judge to go below even a mandatory minimum sentence. So it can be a very important component for a cooperating witness. But the Justice Manual makes it clear that you have to have supervisory approval before you file this kind of a letter. And this is just a section of the U.S. Sentencing Commission's webpage. So if the government does file a motion under that 5K 1.1 stating that a cooperating witness provided substantial assistance in the investigation or prosecution of another person who has committed an offense, there are certain factors that the court is supposed to consider in determining an appropriate sentence for that cooperating witness. Those include the significance and usefulness of the cooperating witness's assistance, taking into consideration the government's evaluation of that assistance, the truthfulness, completeness, and reliability of the information or testimony the cooperating witness provided, the nature and extent of the cooperating witness's assistance, any injuries suffered or the risk of any injuries suffered by a cooperating witness or by that witness's family as a result of that witness agreeing to provide assistance, and the timeliness of the cooperating witness's assistance. We don't have quite the requirements that Italy does, but somebody who chooses to come in early to cooperate is going to be afforded a benefit that somebody who chooses to try to cooperate, right before his trial date. Even if that kind of person was permitted to cooperate, the fact that it took him a long time to choose to try to do so would be something the judge would consider and could certainly result in a slightly higher sentence. So now I'll talk a little bit about the approach of my former office, which I think is actually somewhat unique even among the federal prosecutors' offices in what it requires of cooperating witnesses. This is the office depicted in Billions. I haven't watched Billions, so I apologize. I know one of the first speakers talked about that. I'm going to assume it's probably not 100% accurate, just because that's usually the case of any kind of fictionalized representation, but this is that office. So the process to sign up a cooperator, that is to determine whether you're going to let somebody enter into a cooperation agreement. As a prosecutor, you debrief that person multiple times. For less serious cases, that may be 5 times. For really serious cases, I met with defendants 10 or 20 times before deciding whether to sign them up. It was just incredibly important that you fully believed what it is that this person had to say if you were even going to enter into a cooperation agreement with them. And in those debriefings, you'd have the potential cooperator, the prosecutor, the defense attorney for that witness, and law enforcement. You'd always have your agents with you or your detectives. Those conversations would be subject to something called a proffer agreement. It basically puts certain limits on how the information that witness provided during one of those sessions could be used. As an example, you couldn't use what somebody told you in a proffer session to introduce against him at his own trial if he chose to not cooperate or you chose not to let him cooperate. You could, however, use that information to develop leads to try to obtain admissible information. So, as an example, if somebody told you that they had buried a body at a particular location, you could not introduce the fact that that person told you that that body was there, but your agents could go out, they could try to find the body, and if they found the body and you were able to introduce other evidence, you could introduce the fact that there was a body there, and you could try to tie it to the defendant through some other way. So the proffer agreements gave the defendants some protection when they were choosing to talk with us, while still allowing us not to pretend that information that we knew wasn't true. There would sometimes be sort of pre-guilty plea cooperation type letter that would allow a defendant to do some sort of proactive work for us, but wasn't as formal as a cooperation agreement, and made it clear that the government was not obligated to make one of those 5K 1.1 motions at the time that the defendant was sentenced, unless he successfully cooperated throughout the whole process. The approval process, an individual prosecutor could not choose to sign up a cooperating witness. You would speak with your supervisor, there would be approval high up in the office, you would write something called a cooperation memo that talked about the potential cooperating witness's crimes, talked about the use that he may be able to provide, talked about a number of factors, and that would be reviewed by your supervisor and by people who are higher up in the office. You would also draft a charging document. Usually in the US, people are charged by indictment, which requires you to go to the grand jury. If somebody wishes to cooperate, they're required to waive that right to have you go to the grand jury to charge them, and you instead have an information. Then the supervisors and the other people in the office would also review the actual cooperation agreement. Sometimes there would be oversight from Main Justice from Washington, D.C. for particular types of cases involving racketeering, cases involving potential capital offenses. So you'd also have to convince people in Washington, D.C. that signing a cooperator up was the right thing to do. And this is, I think, an important part of how my former office handled cooperation. And that is that the defendant would have to plead guilty to everything. There was no benefit at the front end for a cooperating witness in the Southern District of New York in terms of what it is that that person pled guilty to. The benefit would potentially come on the back end when the judge chose to sentence the defendant to potentially much less time. But the defendant himself would have to plead guilty to every single crime that he admitted to during those proffer sessions, or that you could prove otherwise. They're also required to tell the truth, commit no more crimes, cooperate, that is potentially testify at trial. Oftentimes there was a financial penalty, like a forfeiture, that is having to give up the money that you stole, if you stole money, or restitution, that is trying to make victims whole, if it was a case that involved victims. Violent crime cases often included information about witness protection, which gets to some of the same safety issues that I know are an issue in Italy. Sometimes these would be under seal, that is, the courtrooms would not be accessible by the public. Information would not be made publicly available on the online documents, but you had to seek approvals for things to be under seal, and at some point, almost everything is unsealed. You have to show that there's a risk to the person's safety and or a risk to an ongoing investigation for something to be under seal. Oftentimes with cooperating witnesses, those were easy things to show. So again, at sentencing, that's when the potential benefit to a cooperating witness comes. It is that the government provides information to the judge that the judge then takes into account in determining the appropriate sentence. If a cooperating witness fails, if a cooperating witness lies or commits another crime, what would happen would be that they would have already pled guilty to all of those very serious crimes, and the prosecutor would no longer be obligated to send in that 5K 1.1 motion. So the upshot is that the defendant who attempts to cooperate in that office and doesn't fulfill his end of the bargain typically ends up doing even more jail time than he would have done if he just asked for a regular guilty plea at the front end. So you have these pretty powerful things in place to encourage cooperators to fulfill their ends of the bargain. Thank you. At my old office, we would never make a sentencing recommendation. We would only provide the information to the judge, and the judge would choose what to sentence. But sometimes the judges would want to know what kind of sentencing range a defendant might have had if he'd only pled guilty to the original charges. In cases where a cooperating witness admits to additional serious conduct, this allows the judge to take into account what that person might have gotten if he had just pled guilty in determining what the appropriate sentence would be. This system works only because in that district, the judges and the prosecutors and the defense attorneys understand it and trust it. Now, I'll talk a little bit about two other ways to end cases and to oftentimes secure cooperation or testimony of witnesses. And those are immunity orders and non-prosecution agreements. There are a couple of key differences. For an immunity order, it's an order from a judge, and it binds, that is, it controls both federal and state government. If somebody is subject to an immunity order and testifies as a result of that, nobody can use that information to charge that person. It includes approval in Washington, D.C. For a non-prosecution agreement, it's only between the U.S. Attorney's Office, who's entering into it, and the person who is the subject of it. So what that means is, I don't know if news of Jeffrey Epstein made its way down here. He was somebody who'd been charged in Florida with some serious crimes involving the sexual assault of girls, was subject to a non-prosecution agreement by the U.S. Attorney's Office down there. Recently, my former office charged him, including about some of the same conduct that had been the subject of that non-prosecution agreement, and there was no problem with that. There was no barrier to that, because a non-prosecution agreement is only between the office and the defendant, or the potential defendant. And I think that I know that our time is a little bit short. I think that you have a good enough idea of what the immunity orders and non-prosecution agreements sort of generally require. I will give just one example of each of them so you have an idea of when they can be used. So in one of my cases where we went to Washington, D.C. and to the judge to request an immunity order, it was a woman who had smuggled information out of a prison for her boyfriend. She did not want to cooperate. We had some concerns that this information might make some of our witnesses unsafe, and so we requested an immunity order, obtained that, required her to testify before the grand jury about the subject of those messages so that we could make sure that we were keeping our witnesses safe. Again, she didn't want to do that. The immunity order allowed us to require her to when we made the findings that showed it was in the interest of justice to do that, and that was the way that we were able to move forward to get that information. In another case, we used a non-prosecution agreement with a person who drove for FedEx, one of the package delivery services in the United States. He had stolen about $30,000 of drug money from somebody who also drove with him, and came to us several years later after that other co-driver started threatening him and his family with bodily harm as a result of stealing that money. So we decided that the appropriate thing to do was to subject this FedEx driver to a non-prosecution agreement. That allowed us to ask him to have some calls with that guy who was threatening his family to ensure that he was able to testify. We also required him to forfeit, as part of that non-prosecution agreement, that $30,000 of drug money that he really, really regretted stealing. So this gives you some ideas of the different mechanisms that we use in the federal system in the U.S. to enter into guilty pleas with people, to enter into cooperation pleas with people, and to end cases in other ways. There is one other way to end a case, and that's with a deferred prosecution agreement. I just want to mention that that is another possibility in this universe, and I'd be happy to talk about that more later.